Fired bank employee. Key distinctions of Canadian bank job firings, terminations, layoffs, and quitting. Losing your banking job with a major Canadian bank can be an extremely brutal experience. Given that your former employer is one of the largest Canadian companies, with a market capitalization in the tens of billions of dollars, seemingly unlimited financial resources, and a platoon of high-priced lawyers working relentlessly at their bidding. However, even with such apparently formidable odds, when you are fired, terminated, laid off, or even quit your bank job, you should not simply accept everything that the bank and their lawyers tell you as being the whole truth and nothing but the truth. For even though they might like you to believe that they can do no wrong, the truth would appear to be far more dark and sinister, as is evident from their own publicly available documentation and what it means for the bank's own employees, if it is broken down and deciphered correctly. The challenge for Canadian bank employees in understanding and dealing with the end of their bank employment, be it when fired, terminated, laid off, or quit, resigned, are the distinctions that differentiate bank employment from most other employment arrangements in Canada. For unlike most other employees of a Schedule 1, 2, or 3 bank, as distinct from community and regional banks, are not subject to their province's employment standards legislation, but instead the Canada Labour Code. The Canada Labour Code provides legal protections and minimum payment requirements for employees working in specific areas of employment of national consequence. Although many of those areas are unionized federal jobs, such as the federal government employees, airline workers, and rail workers, which provides for alternate procedures and representation that is distinct from bank employees and other non-union Canada Labour Code employees. From a comparative standpoint, the Canada Labour Code provides far more lenient payroll reporting requirements than certain provincial employment standards legislation, such that bank employees are not necessarily apprised of key information that goes into their payroll calculations. But even here, there are additional protections set out in the regulations of the Canada Labour Code, which bank employees should avail themselves to, or alternatively use to their legal advantage. And even though there might be a considerable number of data points provided to a bank employee in their pay statement, those data points require a considerably greater dive into the computational processes and statutory prerequisites to understand whether or not there has been the necessary legal compliance. For unlike certain provincial employment standards legislation, the Canada Labour Code does not provide comparable clarity without a thorough analysis of what the legislation actually requires and results in. It is actually necessary to relinquish all preconceptions as to payroll and read the Canada Labour Code without those preconceptions, so as to properly understand what is required from the Canadian Labour Code and how calculations are actually done. Without this foundational work, which is specific to the Canada Labour Code, critical aspects have gone largely overlooked, and this is evident from the lack of court litigation to address and correct those matters that in fact violate the Canada Labour Code and adversely impact bank employees when fired, terminated, laid off, or quit their job. Furthermore, because of certain public reporting obligations, Canadian banks are mandated to publicly report certain information, which, although vetted by their very expensive lawyers, clearly for other legal reasons, those particular documents reveal the basis to discern statutory violations as to their bank employees. Meanwhile, with the Canada Labour Code providing for both statutory termination pay and severance pay, with statutory minimums being greatly exceeded by Canada's major banks when releasing a bank employee, lawyers have rarely been asked to heavily scrutinize a bank employee's termination or layoff package, given that lawyers tend to look at them merely from a comparative standpoint to other industries, such that they far too quickly indicate that the proposed payout is more than reasonable. This has begun to change with recent court litigation against Canada's major banks, such as the class action cases of Fresco versus CIBC, Canadian Imperial Bank of Commerce, Cheatham versus BMO, Bank of Montreal, Cunningham versus RBC, Royal Bank of Canada Dominion Securities, Barrett versus RBC, Royal Bank of Canada Insurance, and Chiang versus TD Toronto Dominion Bank. However, as suggested by numerous employment lawyers unconnected with our law firm, these class action lawsuits potentially only represent the tip of the iceberg. And in our professional opinion, this is an understatement, with these earlier lawsuits only scratching the surface as to what is wrong with Canada's major banks and the employee underpayments that have occurred, and which bank employees who are fired, terminated, laid off, or even quit their job with any Canadian bank needs to fully scrutinize, as the legal issues ultimately boil down to money that has been fully earned and for which they are legally entitled to. But for the perception of Canadian banks being incapable of making financial-related mistakes and protected by the highest paid lawyers in the country. However, bank payouts should demand more scrutiny, given what we already know based on our review of the bank's own public reporting and is confirmed by other information and material that has been placed into the public domain. If you are a bank employee that has been fired, laid off, terminated, or quit their banking job, even in the past few years, contact our law firm to schedule a free, confidential initial consultation. Thank you.